So we've talked a little bit about jurisdiction, so let's go through the chapter of jurisdiction. Chapter 2 of criminal law. What is the jurisdiction of federal government to enact criminal laws in the United States? Well, we operate under a system of federalism. Federalism is the separation of the 50 states from the federal government. The two work together, and they do the work of the United States Constitution and the individual state constitutions. The federal government does not have any inherent police power in and of themselves. They only derive their police power from the United States Constitution. So every federal criminal statute must trace its jurisdictional origin to one of the powers enumerated in the Constitution. An activity that is solely within the single state can be regulated by states and local communities, but not by the federal government. The federal government does not have jurisdiction in a case that occurs within that single state, with a few exceptions, which we'll talk about in a minute. The states and the federal government are two separate jurisdictions. Those classified under federal jurisdiction, federal crimes, are fraud, U.S. mail, fraud on the U.S. mail, bank robbery of a federal bank, violation of federal income tax laws, offenses by or against federal officers, and finally, crimes beyond jurisdiction of any state, or crimes between two states or disputes between two states. Some other federal jurisdictional powers: crimes that affect interstate or international travel or communications, crimes committed in places beyond the jurisdiction of any state. These can include crimes committed in the District of Columbia, crimes committed overseas by military or U.S.-controlled ships or aircraft, or crimes that interfere with the activities of the federal government, such as federally insured savings and loan institutions, a violation of federal income tax laws, and attempted overthrow of the United States government. Those all fall within federal jurisdictional powers. So we've all seen the federal government come in and take over murder crimes on every television show that we watch. But where does the federal jurisdiction for murder come in? So some of the situations where criminal homicide can be a federal crime is within special maritime and territorial jurisdictions, when the death results from terrorism, sabotage, or certain cases of reckless or negligent destruction of federal transportation facilities, when the victim is a high-ranking U.S. government official, when the victim is engaged in performing federal functions, when death occurs in connection with any federal crime, when the homicide occurs during an offense defined by the Civil Rights Act of 1968, or when an American citizen is killed anywhere in the world under the Comprehensive Crime Control Act of 1984. That's a fairly limited scope for murder to be handled by the federal government. Now, there are some federal crimes on the books that do help and support local and state law enforcement. Unlawful flight statute, the Fugitive Felon Act, federal kidnapping, federal conspiracy, the RICO statutes that allow the government, local government, to be able to seize assets of a criminal conspiracy. The federal domain is nothing more than what the federal government owns for land, and right now they own about a third of the land in America. So a third of the territory in the United States is owned by the federal government. Federal enclave territories and Assimilative Crimes Act, and the expanding federal criminal code, which we'll talk about. There's another one that I've found very useful, the Mann Act. The Mann Act was enacted back in the 1920s as a means of keeping people from traveling between states for the purpose of prostitution. So what we use it for in human trafficking is when a trafficker takes a victim across state lines for the purpose of prostitution, they can be we can use the federal government's resources to be able to handle that human trafficking crime on either the federal or the state level. Federal enclaves. This is the land owned by the United States. It includes military installations, national parks and forests, federal buildings, post offices, federal court buildings, federal office buildings, and Native American reservations also fall under this category of federal enclaves. So there's nation to nation jurisdiction, so one country to another, and these are some of the specific circumstances. The laws of a nation follow its ships and aircraft. So if a ship from one country is ported in another country, on board that ship is still the jurisdiction of the country in which it was was sent by. Extraordinary rendition, we've seen this in wars in the past. Extraordinary rendition is the practice of seizing foreign nationals in one country and transporting them to another country for questioning or prosecution. The U.S. has also joined with other nations to define offenses against the law of nations by international treaties and conventions. And the International Criminal Court, the ICC, was the first permanent war crimes court and was created in 2002. So one final thing to look at when we're talking about jurisdiction is extradition. Extradition is the removal of a person from one jurisdiction to another so that he or she can face charges in the requesting jurisdiction. This can be done on a state-to-state level, where one state requests the extradition from another state. It also can be done at the international level, and this involves treaties between the United States and foreign countries. And if those countries do have an extradition treaty with the United States, then fugitives can be returned to the United States for prosecution. There are countries where there is no treaty in place, and so there is no extradition permitted in those areas. So when we're looking at the military martial and war powers jurisdiction of the federal government, most of this will fall within the Uniform Code of Military Justice. That is a separate court arrangement within the military system. The armed service members, the military court may try service members for crimes committed on or off military bases. The military courts have no jurisdiction over United States citizens who commit crimes, even if they are on military bases. However, civilians working with military units can also be subject to the Code of Military Justice. Terrorists or enemy combatants, they are non-citizen terrorists seized by the military, may be tried and detained by the military. Non-citizen enemy combatants may be held by the military, and enemy combatants who are United States citizens are entitled to trial in federal courts, not in the Uniform Code of Military Justice. Native American reservations are sovereign nations under federal law, and thus they do get some degree to regulate themselves. Major crimes, the Major Crimes Act removed the jurisdiction from enumerated crimes, in other words, the more heinous type crimes, crimes by non-Indians are outside the jurisdiction of tribal courts. So a non-Native American committing a crime within the jurisdiction of the reservation has to be handled by the state in which that reservation coincides. The Native Americans who commit crimes while not on or within the reservation or in Indian country are subject to the laws of the state or government where the crime was committed, not under the reservation law. Tribal courts are now generally limited to jurisdiction over crimes committed by Native Americans on tribal lands where the penalty is imprisonment for 1 year or less. That legislation has increased the maximum sentence, but for the most part, the tribal lands here misdemeanor crimes, and the state or federal government hears felonies.